I'm Kimberly McGhee, an attorney at Black & McGhee in San Diego County, and today I'm going to be discussing limited conservatorships. As we learned in the conservatorship videos as part of this series, if a person lacks certain capacities and requires a court to appoint a person to make legal decisions for them, that procedure is called a conservatorship. The conservator is a person who is appointed to make decisions, and the conservatee is the person who is unable to make their own decisions. One of the types of conservatorships is a limited conservatorship. If your loved one is an adult with a developmental disability and who is unable to provide for their personal and/or financial needs, then this is the type of conservatorship you would like to pursue. A good rule of thumb in determining what type of conservatorship is appropriate is that if your loved one is eligible to be a regional center client, then your loved one is determined to be an adult with a developmental disability. It is most common that you would need a conservatorship of the person if this is the case, because the majority of developmentally disabled adults do not have assets or income that are not tied to some sort of public benefit such as SSI. If your loved one has assets or income that is not limited to Social Security, you may also need to explore a conservatorship of the estate. It is important to note that if the adult with a developmental disability is receiving public benefits, for example SSI or Medi-Cal, then you may also be eligible for a fee waiver when you file a petition for limited conservatorship. This could be a savings of at least $400 for the filing fee, or up to $800 for something like the court investigator's fees. So how does a limited conservatorship work? First, you will need to complete and file a petition for limited conservatorship. There are court-required forms for this type of conservatorship, and they must be completed along with the attached documents. The process for a limited conservatorship has very specific forms, and I highly recommend that you seek assistance through a competent lawyer or through a county legal aid clinic or some workshop, which are generally available in your local courthouse. In a limited conservatorship, there are specific powers that you must ask for. These are the power to fix conservatee's residence or dwelling, the power to access the conservatee's confidential records or papers, the power to consent or withhold consent from marriage on behalf of the conservatee, the power to enter into contracts on behalf of the conservatee, the power to give or withhold medical consent on behalf of the conservatee, the power to select the conservatee's social and sexual contacts and relationships, and the power to make decisions regarding education. Once the petition is filed, the court will appoint a lawyer to represent the interests of the proposed limited conservatee, and that attorney will review the petition with the proposed limited conservatee. These services are free unless the proposed conservatee can afford them. The court-appointed attorney will then meet with your loved one and inquire as to whether they object or consent to the conservator's requested powers. The court-appointed attorney will then prepare a report and file it with the court as to the proposed conservatee's position. A petition for limited conservatorship must also be served on the regional center. The regional center will then also investigate as to whether it is an appropriate request, and then they will also submit a report to the court as to the requested powers. Lastly, the court will also review a capacity declaration which the petitioner must submit to the treating physician of the adult with a disability to determine the doctor's position as to whether the requested powers are appropriate. It is important to remember that the conservatorship takes away constitutional rights and your loved one's rights to make their own decisions, so it is not taken lightly. Once a court appoints a limited conservatorship, the court will supervise that limited conservator, who will have to report at least annually to the court. A court investigator will review the case once a year after the conservatorship is granted, then every 2 years thereafter. The investigator will also visit with the conservatee. I would like to again remind you that if the proposed conservatee receives public benefits, then a fee waiver should be requested by the petitioner, and that any fees for the court investigator should also be waived. Lastly, if you have any questions about this process, please reach out to your local court conservatorship clinic or workshop. disabilities right advocacy groups, or any other qualified attorney, and they'll be able to help you navigate this process. Thank you for your time today.